He looked down at her from that bench, like she was something scraped off the bottom of his shoe, like she was nobody, like she had wandered into his courtroom by accident and would be lucky to walk back out without handcuffs on her wrists. He made her feel small on purpose. He made her feel confused on purpose. He performed his dominance the way a man does when he's been performing it so long he doesn't even realize it's a performance anymore. It had become instinct. It had become identity. But here is what Judge Raymond Caldwell did not know on that ordinary Wednesday morning in the third-floor courtroom of the DeKalb County Judicial Center. The quiet woman standing before him in the worn gray blazer and the sensible flat shoes wasn't trembling because she was afraid. She was completely, devastatingly still because she was watching, cataloging, filing every word, every sneer, every dismissive wave of his hand into a mental folder that would eventually become the document that ended his career. She had done this before, she would do it again, and she was extraordinarily good at it. This is the story of how one woman's patience, her precision, and her absolute refusal to react on anyone else's timeline became the most powerful legal weapon in the state of Georgia. And it's the story of how a man who believed his title made him untouchable found out, in the most brutal and public way imaginable, that the woman he tried to humiliate was the single human being on earth with the most power over his future. Pull up a chair, this one is going to leave a mark. Before we walk into that courtroom, you need to understand the geography of power in DeKalb County Superior Court. And specifically, you need to understand who Judge Raymond Caldwell was, because context is everything in a story like this. Caldwell had been on the bench for 19 years of absolute authority inside those four walls. He was the kind of judge who had convinced himself that the law and his personal opinion were the same thing, that his instincts were infallible, that the robes he wore didn't just grant him legal authority. They confirmed a fundamental truth about his superior intelligence and his rightful place at the top of the social order. He was 61 years old, heavy-set in the way of a man who had eaten every meal like it was his last, with the florid complexion of someone whose blood pressure was perpetually in argument with the rest of his body. He had a deep, resonant voice he wielded like a carpenter's hammer, pounding it against defendants, witnesses, and lawyers who annoyed him with equal enthusiasm. He laughed at his own jokes. He made the court reporters nervous. He made the bailiffs nervous. He made opposing counsel, even the experienced ones, stutter slightly when they addressed him. His chambers were decorated with framed photographs of himself with state senators, a mounted base from a fishing trip in 2011, and a hand-stitched needlepoint that read "Justice is blind," a piece of decor that everyone in that courthouse understood as being deeply, almost comically ironic. Caldwell had a type, not in the way people use that word casually. He had a category of person, he had decided. Somewhere in the accumulated sediment of his biases was unworthy of his time, his patience, or his basic courtesy. That category included anyone who showed up to his courtroom without a lawyer. It included people who seemed poor. It included people who were too young, too nervous, too unfamiliar with legal procedure to push back when he was wrong. And it included black women in particular, whom he had developed a uniquely weaponized condescension toward, a tone that was somehow simultaneously dismissive and aggressive, managing to communicate both "you don't matter" and "don't you dare challenge me" in the same sentence. He had never been formally disciplined, not once in 19 years. He was connected, he was careful enough, or thought he was. He had enough allies in enough powerful offices that the few complaints lodged against him over the years had evaporated quietly into the bureaucratic atmosphere, never coalescing into anything he had to actually address. He believed he was fireproof. He was wrong by approximately 1 week. The woman who walked into courtroom 3C on that Wednesday morning was named Vivienne Cole. At least, that was the name on the docket. That was the name of the plaintiff in the case of Cole versus Harrington Heights Community Association, a modest civil matter involving a contested property survey and an alleged violation of HOA landscaping rules, a fabricated dispute, a manufactured grievance built with surgical precision to do exactly one thing: put Vivienne Cole inside that room, inside that judge's crosshairs, and give him enough rope to hang himself with. She was dressed carefully. A blazer that had seen better days, a white blouse buttoned to the collar, sensible shoes, simple earrings. She carried a manila folder pressed to her chest with both hands the way someone does when they're not quite sure what to do with themselves in a formal setting. Her natural hair was pulled back tightly. She wore oval-framed glasses that caught the fluorescent light. She looked, to any observer who wasn't paying close attention, like a woman who had taken a day off work to fight an unfair fine and was already slightly terrified by the magnitude of the room. She had spent 3 hours that morning transforming herself into that woman. The transformation was meticulous and intentional. Because Vivian Cole, the real one, the one who existed outside that carefully constructed performance, was one of the most formidable legal minds in the southeastern United States. Dr. Vivian Cole, J.D., LLM, had graduated first in her class from Georgetown University Law School. She had spent 7 years in federal civil rights litigation before pivoting to judicial oversight work, spending 2 years at the Department of Justice before accepting the appointment that now defined her professional life. She was, as of 14 months ago, the executive director of the State Judicial Conduct Board, the independent constitutional body responsible for investigating, disciplining, and removing unfit judges from every court in Georgia. She was, in other words, the person Raymond Caldwell would have been most desperate to impress had he known she was coming. Instead, she walked into his courtroom looking like prey, and Caldwell, being exactly the kind of man he was, could not resist. She arrived early. She always arrived early when she was working. She settled into the third row of the gallery and spent the first 90 minutes watching. Just watching. Not reviewing case files, not checking her phone. Just observing Raymond Caldwell operating in his natural environment, unbothered and unaware. What she saw in those 90 minutes made her file at home feel inadequate because the file couldn't fully capture the sheer theater of the man's cruelty. It had to be experienced live. She watched him interrupt a young public defender 11 times in the span of a single argument, not to ask questions, but simply to demonstrate that he could. She watched him deny a motion from a Spanish-speaking grandmother who was trying to explain a lease agreement through her nephew, cutting the nephew off mid-translation with a pointed public command to conduct yourself in the language of this court or find somewhere else to be. The gallery had gone very quiet after that. The kind of quiet that meant everyone was uncomfortable, but no one felt safe enough to say so. She watched him grant a summary motion for a corporate real estate firm without reading the opposing party's response brief. She watched him lean across the bench to exchange a murmured joke with a silk-suited attorney she recognized as the County Bar Association's treasurer and one of Caldwell's regular Thursday morning tennis partners. She watched the judge grant that same attorney's motion 60 seconds after the joke, a motion the opposing pro se litigant, an elderly black man in a church suit, had been articulating a response to for 4 minutes before being cut off. The elderly man sat back down slowly. He folded his hands in his lap. He looked at the floor. Vivian's pen moved across her notepad without her eyes leaving the bench. She had seen enough to know that the complaints were accurate, but she needed him to do it to her specifically. She needed it documented, authenticated, and delivered on the official record in her own presence so that no defense attorney could argue witness, credibility, or selective documentation. She needed Raymond Caldwell to be Raymond Caldwell, in his fullest expression, aimed directly at the one person whose testimony before the board would be unimpeachable. She closed her notepad when the clerk called her case. Cole versus Harrington Heights Community Association. Parties, please approach. She walked down the center aisle the way she had practiced, shoulders slightly rounded, pace slightly hesitant, folder clutched a touch too tightly. She stepped to the plaintiff's podium and stood with the particular stillness of someone trying very hard to appear composed when they feel out of place. Across the aisle, opposing counsel materialized from the gallery. His name was Philip Stowe, a 63-year-old HOA specialist with silver hair, a striped tie, and the specific brand of effortless confidence that comes from knowing the judge is going to rule your way before you've opened your mouth. He had practiced in DeKalb County courts for 30 years. He and Caldwell had served on the same bar committee for 11 of those years. Caldwell looked up from his papers. He took in Stowe with a slight nod, the kind that passes between people who share a mutual understanding about how the world works. Then his eyes moved to the plaintiff's podium, and what crossed his face wasn't malice exactly, at least not yet. It was something earlier than malice. It was assessment, rapid, reductive, deeply conditioned assessment. He saw the blazer. He saw the flat shoes. He saw the folder. He saw Vivian. He made his decision in approximately 2.5 seconds. "All right," Caldwell said, his voice carrying the bored authority of a man who had already decided how this would end. "I see Mr. Stowe for the defendant." And for the plaintiff, he glanced at the sheet, mispronouncing her name with the particular carelessness of someone who didn't think pronunciation was worth the effort. "Miss Cole, you representing yourself today?" "Yes, Your Honor," Vivian said quietly. "I'm appearing pro se." Caldwell exhaled through his nose, a sound that managed to communicate more contempt than most people could convey in a full sentence. He set down his pen.
Pro se.
He repeated it back to the room, not to her, but to the room, as if he were sharing an observation with the general public about the quality of his caseload.
Pro se, of course.
He looked over at Stowe, who offered a thin, practiced smile of commiseration. Miss Cole, I'm going to give you some free advice, because clearly nobody else has. Representing yourself in a civil proceeding isn't noble, it isn't brave, it's a liability. Courts aren't self-service kiosks. The law doesn't care that you watched a YouTube video about property lines. Several people in the gallery shifted in their seats. I appreciate the guidance, Your Honor, Vivienne said. She kept her voice low and deferential, edged with exactly the right amount of manufactured uncertainty. Let's get through this quickly, Caldwell said, settling back. Mr. Stowe, summarize for me. Stowe opened his folder and delivered a clean, 3-minute summary of the HOA's position. The plaintiff had installed a garden border structure that allegedly violated the community's landscaping codes. Section 7, Article 3. The association had issued 2 written notices. The plaintiff had not complied. They were seeking a removal order and reimbursement of the administrative processing fees. Thank you, Caldwell said warmly. Then he looked at Vivienne. The warmth didn't travel. Miss Cole, response. Keep it brief, Your Honor, Vivienne began, opening her folder. I'd like to first address the notice issue. The 2 written notices the association references were sent to an address that I had formally updated with the HOA Management Office in writing 7 months prior. I have the confirmation letter here, dated. I don't need the letter, Caldwell interrupted. His voice had taken on a new edge. Not quite irritated yet, but heading there. I need to know why the structure is still there. I'm trying to explain, Your Honor. If the notices weren't properly delivered, the structure is there or it isn't, Caldwell said flatly. It's there. You admit that. That's the ball game. The rest is noise. With respect, Your Honor, the notice requirement isn't procedural noise. It's a jurisdictional prerequisite under the association's own governing documents. Without proper notice, the enforcement action, Miss Cole, Caldwell's voice dropped. He leaned slightly forward. The shift in his posture was subtle but unmistakable, the way a large man leans forward when he wants the other person to feel the difference in their sizes. I've been presiding over cases like this since you were in elementary school. I don't need a pro se plaintiff to explain HOA enforcement law to me. What I need is for you to understand that you are standing on the losing side of a very straightforward dispute, and the kindest thing I can do for you is tell you that plainly before you embarrass yourself further trying to argue points you clearly don't understand. There it was. Not the worst of it, not yet, but the shape of it. The condescension wearing the costume of concern. The belittlement dressed up as benevolence. Vivienne's expression did not change. She looked at him steadily. I do understand the points, Your Honor. That's why I'm raising them. Something flickered behind Caldwell's eyes. Annoyance, mostly. But underneath it, something faintly resembling surprise. People who looked the way she looked, people he had already categorized, were not supposed to push back. That wasn't how the script worked. Mr. Stowe, Caldwell said, pivoting away from her with practiced finality. What is the association seeking, specifically removal of the structure within 30 days and reimbursement of $420 in processing and legal coordination fees? Stowe said. Granted on the removal order, Caldwell said immediately. We'll discuss the fee award. Objection. Vivienne's voice was clear and calm. The court has not allowed me to complete my defense. Ruling before a pro se plaintiff has had a full opportunity to be heard is a due process violation under the 14th Amendment. The temperature in the room dropped 3 degrees. Caldwell slowly turned back toward her. His expression had completed its journey. It wasn't annoyance anymore, it was fury, the cold, measured kind that comes from someone who is not accustomed to being contradicted and is now processing the contradiction as a personal affront. What did you say? I said respectfully, Your Honor, that I haven't finished my argument, and I'm entitled to finish it. Caldwell sat back. He stared at her. You have some nerve, he said quietly, and the quiet made it worse than a shout would have. You come into my court without legal training, without competent representation, and you want to lecture me about due process. Let me tell you something, Miss Cole. He was leaning forward again. I have been on this bench longer than you've probably held a job. I have presided over thousands of cases. I have forgotten more law than you will ever know. And I will not sit here and be corrected by someone who doesn't know what she doesn't know. Do you understand me? I understand that you've been on the bench a long time, Your Honor. Then act like it means something. His voice had taken on a contemptuous, almost performative edge now. He was playing to the room. You people come in here with your Google searches and your 2 paragraphs of second-hand knowledge, and you think that's enough to challenge a sitting judge. It isn't. Not even close. He turned to the bailiff briefly, a half glance, the kind that means watch her, then back to Vivienne. I am ruling on this matter. You will accept that ruling. And if you open your mouth again to challenge my authority in this courtroom, I will hold you in contempt. I want to be absolutely clear about that. Contempt. Do you understand what that means for you practically? It means that bailiff over there puts you in a holding cell and you sit there until I decide you've had enough time to think about your attitude. The gallery had gone completely, eerily still. A woman 2 rows behind Vivienne had stopped breathing. A man near the exit had his hand half raised to do something, he wasn't sure what, and then slowly lowered it. Vivienne Cole stood at the podium and looked at Raymond Caldwell with the expression of someone who had been waiting a very long time for exactly this moment to arrive. I understand, Your Honor, she said. Her voice was perfectly controlled. I just want to ensure the official record is complete. Court reporter, she turned, briefly and deliberately, toward the stenographer at the side of the room, a detail Caldwell had clearly not thought about in any meaningful way in years. Did you capture the judge's statements in full, including the reference to you people, the characterization of my knowledge as inadequate on the basis of my apparent background, and the conditional contempt threat preceding any ruling? The court reporter's fingers paused. Her eyes went to Caldwell, then back to Vivienne. Then she nodded, slowly. Yes. It's all on the record, ma'am. Thank you. Caldwell's face had gone the color of a brick left in the summer sun. That is, you do not get to direct communications to my court reporter. You do not get to... He stopped. He collected himself with visible effort, the muscles along his jaw working. He picked up his gavel and brought it down with a crack that made 3 people flinch visibly. This case is concluded. Removal order granted. Get out of my courtroom. Vivienne gathered her papers. She took her time doing it. She aligned the edges. She closed the folder. She looked up at Caldwell one final time. Thank you, Your Honor, she said. I'm sure our paths will cross again. He scoffed. He was already reaching for the next file. I doubt that very much. She walked up the center aisle, through the double doors, and out into the marble corridor of the DeKalb County Judicial Center. The doors swung shut behind her. She pulled out her phone and dialed a number she had memorized years ago. James, she said. Her voice was entirely different now. The hesitancy was gone. The manufactured uncertainty had evaporated completely, replaced by something clean and precise, and absolutely decisive. Pull the transcript request forms. I need an authenticated copy of the 3C recording from this morning, audio backup included, signed off and delivered to my office by 5 o'clock. And tell the team to start drafting the formal charge documentation. We're moving. How'd it go? James asked. Better than I expected, Vivienne said. And I expected quite a lot. The Georgia State Judicial Conduct Board occupied the 17th floor of a glass building in Midtown Atlanta. Most judges in the state knew its name in the abstract, the way people know the name of a hospital they've never had cause to visit. They knew it existed. They knew it had theoretical authority over their careers. They did not spend a lot of time thinking about it concretely, because for most of its institutional history, the board had operated with all the aggressive momentum of a parked car. That changed 14 months ago when the governor, facing significant public pressure following a series of high-profile judicial misconduct scandals, appointed a new executive director and restructured the board's investigative protocols from the ground up. The appointment was considered something of a political surprise. The nominee was young, 41. She lacked the connections to the county courthouse machine that had historically populated the board's leadership, and she had a professional reputation built almost entirely on her willingness to go after powerful people without apparent concern for what that would mean for her own career trajectory. Her name was Dr. Vivienne Cole, and the judges of Georgia had spent the past 14 months quietly but urgently recalibrating their behavior in ways large and small because word had reached them, in the particular informal telegraph system of the legal community, that the new executive director was not interested in written apologies and sensitivity workshops. She was interested in outcomes. She was interested in patterns. She was interested in cases that had been dropped by previous administrations because the subject had too many political friends to make the fight comfortable. She had already removed one judge, a family court commissioner in Savannah whose practice of routinely denying custody to non-English-speaking parents had gone unaddressed for 6 years. He was gone in 11 weeks from the first formal complaint. 11 weeks. The previous board had sat on similar complaints about him for 3 years without acting. Raymond Caldwell had heard the stories. He had heard them and made a calculation that most powerful men in comfortable positions make, that stories are about other people, that the forces being described were real but not applicable to him specifically, that he was different, that he was protected. He had made, in other words, the classic error of confusing the absence of accountability with the impossibility of it. The envelope arrived on a Tuesday. Caldwell was in his chambers, reviewing motions, when his clerk knocked and entered with the careful movements of someone bringing bad news to someone they're afraid of. She handed him a sealed envelope marked with the state seal of Georgia and the return address of the Judicial Conduct Board, and she left the room slightly faster than she had entered it. Caldwell opened it with the mildly irritated energy of someone expecting minor inconvenience. He read the header. He read the charges. His eyes moved slowly down the page, and then stopped. Cole versus Harrington Heights Community Association. DeKalb County Superior Court. Courtroom 3C. Date of incident. He read it a second time. His hands had gone very still. He thought about the woman at the plaintiff's podium. The worn blazer. The flat shoes. The oval glasses. The folder. The absolute specific way she had turned to the court reporter and asked whether the record was complete. He thought about the gavel. He thought about the contempt threat. He thought about you people. He thought about the way she had said, "I'm sure our paths will cross again," with the calm certainty of someone describing a thing they had already arranged. He reached for his phone. His hands were not entirely steady. "Get me Harlan Morris," he said, when his clerk picked up. "Now! Tell him it's urgent." Harlan Morris was the most expensive judicial misconduct defense attorney in Georgia. He was 70 years old, had a face like seasoned leather, and operated with the exhausted competence of a man who had seen every variety of catastrophic professional self-destruction and had long since stopped being surprised by any of it. He arrived at Caldwell's chambers within the hour, read the formal notice of proceedings in full, set it down on the desk, and looked at his client for a long moment without speaking. "Talk to me about the woman," Morris said finally. Caldwell talked. He described her the way he remembered her. Ordinary, nervous, out of her depth, clearly unsophisticated. He described the case as minor. He described his own conduct as firm but appropriate, given her repeated interruptions and challenges to his authority. Morris listened. He asked 2 questions. "Did you use the phrase, 'you people'? And did you make explicit reference to a contempt action before ruling on the motion?" Caldwell was quiet. Morris exhaled very slowly through his nose. "The new executive director of the Conduct Board is named Vivian Cole," he said. "I want you to look at the plaintiff's name on that notice one more time." Caldwell looked at the notice. He looked at the plaintiff's name. He looked up at Morris. "She set you up," Morris said. "It wasn't an accusation. It was an autopsy. This wasn't a fence dispute. There is no Harrington Heights landscaping violation. She manufactured the case specifically to get into your courtroom, knowing exactly how you would respond to what you thought you were looking at. And she documented everything, on the record, with the court reporter, with the audio backup, with her own first-hand testimony as a named party in the proceeding." He paused. "The star witness against you is the judge of judges. There is no cross-examination strategy in existence that survives that." Caldwell sat very still. "What's my option?" he said finally. "Humility," Morris said. "Profound, total, sustained humility. We appear before the board on Thursday. You say as little as possible. You express remorse. You mention the blood pressure medication, the heavy caseload, the 19 years of otherwise unblemished service. You throw yourself on whatever mercy exists in that room, and you hope to God she's willing to consider a censure and mandatory retraining over full removal." He stood up, collecting his papers. "But Raymond, I have to be honest with you. If Vivienne Cole wanted to be merciful, she would not have spent 14 months and whatever resources it took to engineer this specific situation. She is not in the mercy business." He left. Caldwell sat alone in his chambers under the needlepoint that said "Justice is blind." The Conduct Board's hearing room on the 17th floor was designed by someone who understood that intimidation is architectural as much as it is personal. The ceiling was high, the lighting was direct and unflattering. The semicircular raised platform where the board members sat created an involuntary hierarchy the moment you entered the room, with the respondents' table positioned slightly lower and slightly smaller than physics could entirely account for. Or so it always seemed to the people sitting at it. Caldwell arrived 10 minutes early in his best navy suit. He was accompanied by Harlan Morris and 2 associates. He sat at the respondent's table and folded his hands and practiced the expression of a man who was capable of remorse, which was harder than it sounded because it was an expression he had very little occasion to practice over the preceding 6 decades. The 6 board members entered. They were a mix of appellate judges, senior bar association representatives, and civilian appointees mandated by the state constitution. They sat down. Their faces were the faces of people who had read the file and had significant feelings about it. The center chair remained empty. Caldwell watched the empty chair. He watched the door on the left side of the room, the one connected to the executive suite. He watched it for 4 minutes and 30 seconds, which felt considerably longer. Then it opened. The woman who walked through it was wearing a slate gray suit with double lapels and heels that clicked with quiet authority on the hardwood floor. Her hair was impeccably styled. She carried a binder that she set down on the center desk with a sound like a period at the end of a sentence. She sat down, adjusted her glasses, oval frames, the same ones, and looked directly at Raymond Caldwell. He had known it intellectually since Tuesday. He had known since the moment Morris said her name. But knowing it intellectually and seeing her sit down in that chair were 2 different experiences. And the second one hit him somewhere below the rational mind, in whatever part of a person holds the accumulated weight of their worst moments, the ones they thought no one was watching. The worn blazer was gone. The manufactured uncertainty was gone. The woman who had stood at that plaintiff's podium with her shoulders rounded and her folder clutched to her chest was gone. In her place was someone Caldwell understood immediately, in a deep, wordless, visceral way, to be more powerful than he had ever been at the height of his most untouchable morning. He tried to say something. He wasn't entirely sure what. What came out was a sound low, half-formed, the beginning of a word that didn't make it to completion. Beside him, Harlan Morris had gone completely still. Morris had stopped breathing. Morris, who had sat across from governors and federal prosecutors and never once lost his composure, was looking at the binder on the center desk and then at the case file in front of him, connecting the name on the binder to the name on the file to the woman in the chair with the deliberate slowness of someone who is experiencing a professional catastrophe and needs to absorb it at a survivable pace. He closed his eyes briefly. He opened them. He looked at Caldwell. And then for the first time in a legal career spanning 4 decades, Harlan Morris had absolutely nothing to say. "Dr." Vivian Cole looked at the panel. She looked at the stenographer. She adjusted her microphone. She opened her binder to the first page. "This hearing is called to order," she said. Her voice filled the room without effort, without volume, the way a river fills a valley. "We are here today to address formal disciplinary proceedings against Superior Court Judge Raymond Caldwell of the DeKalb County Superior Court, arising from documented conduct observed on Wednesday, she recited the date, in the matter of Cole versus Harrington Heights Community Association. She looked at Caldwell. "Good morning, Judge Caldwell." Caldwell's mouth opened. "Dr. Cole, I didn't. I know you didn't," Vivian said simply. That was the point. She let that sit in the room for a moment, not cruelly. She wasn't performing cruelty. She was delivering precision. "Before we proceed to testimony," she said, "I want to read several passages from the authenticated transcript of the proceedings in courtroom 3C. These passages have been verified against the audio recording, which has also been submitted as evidence to this panel. I will ask that each panel member have their copy of the transcript open to page 4. The panel members opened their copies. There was the soft sound of pages turning. Then there was silence, as each of them read, for the second time, the words Raymond Caldwell had said to a woman he had judged entirely on sight. She read them aloud. She read them in her measured, clear voice, without theatrical inflection, without emotional amplification, simply reading the words as they appeared on the page. And stripped of the courtroom's acoustic drama, stripped of the gavel and the elevated bench and the bailiff's presence and the manufactured theater of Caldwell's authority, The words revealed themselves in their plainest form, as the words of a man who looked at a person and decided in 2.5 seconds that she was less than him, less intelligent, less entitled to courtesy, less deserving of the basic procedural protections the law guarantees every single person who walks into a courtroom regardless of what they're wearing or how much money they appear to have. When she finished reading, she set the transcript down. "Your attorney will have an opportunity to respond," she said to Caldwell. "But I want to ask you directly. First, the phrase, 'you people,' in the context of addressing a black litigant in the middle of a legal argument she was making, what was your intended meaning?" Caldwell looked at Morris. Morris gave the smallest, most imperceptible nod. I was frustrated," Caldwell said. His voice had lost all of its resonance. He sounded like a man who had set down something very heavy and wasn't sure he could pick it up again. "I was using it as a general expression. I didn't intend any racial—" "What general expression, specifically?" Vivienne asked. "Who are you people in that courtroom, in that moment?" The silence stretched. I can't give you a clean answer to that," Caldwell said. "I know," Vivienne said. "That's the problem." She turned to the panel. She walked them through the documented pattern. The 27 complaints filed in the preceding 5 years. The breakdown by complainant demographics. The comparison of ruling outcomes in cases involving pro se litigants of color versus those involving represented corporate interests. The statistical disparity so pronounced it had been flagged by 2 different law review analyses that the previous board had quietly filed away without acting on. She was methodical. She was devastating. She never once raised her voice. Morris made his arguments. He made them well. He was Harlan Morris. He had been making impossible arguments for 40 years. And he made these as well as they could be made. The blood pressure, the caseload, the otherwise long service, the willingness to submit to remedial training, oversight, supervision, whatever the board felt was appropriate. Vivienne listened to all of it with the patience of someone who has already decided, and is simply allowing the process to complete itself with dignity. When Morris finished, she looked at the panel members. They looked at her. Something passed between them that didn't require words. "This board has considered the evidence," Vivienne said. "We have considered the testimony. We have considered the documented pattern and the incident in question. And we find unanimously that the conduct of Judge Raymond Caldwell represents a fundamental violation of judicial ethics, not as an isolated incident of poor judgment under stress, but as the visible expression of a sustained and systemic bias that has operated in his courtroom at the expense of the most vulnerable people who appeared before him for years." Caldwell had both hands flat on the table. He was staring at the surface of it. "The recommendation of this board to the Georgia Supreme Court is immediate removal from the bench," Vivienne said, "effective upon ratification by the court." She closed her binder. "Additionally, we are forwarding the complete record of these proceedings, including the audio transcript, to the State Bar of Georgia for review of fitness, to continue practicing law in any capacity. And in light of Judge Caldwell's recently submitted application for appointment to a federal appellate position, we are also forwarding the full record to the relevant Senate Confirmation Committee." The federal appointment, Caldwell had submitted the application 4 months ago. He had been quietly confident about it. He had told exactly 3 people. He had no idea the board knew. He looked up at Vivienne. She was looking at him with an expression he couldn't entirely read. It wasn't satisfaction. It wasn't contempt. It was something closer to the expression a surgeon has when the procedure is complete. Focused, clear-eyed, already thinking about the next thing. "This hearing is adjourned," she said. The record was public within 72 hours. The audio clip, 47 seconds of Caldwell's voice in its fullest, most unguarded register, circulated across social media with the velocity of something that has been building pressure for a long time and finally found a release point. It had been shared 2 million times by Friday morning. The political abandonment was immediate and total. The state senator, who had been Caldwell's most vocal backer in judicial circles, released a statement expressing profound disappointment. Philip Stowe, the HOA attorney who had chuckled at Caldwell's jokes 2 weeks earlier, gave an interview distancing himself from any suggestion of a personal relationship with the judge and expressing full confidence in the board's process. The federal appointment was dead before the confirmation committee even received the file. The committee chair released a 6-word statement. "This nomination will not proceed forward." Caldwell hired 2 more attorneys in addition to Morris. He filed an appeal of the board's recommendation. The Georgia Supreme Court reviewed it in 11 days, a pace that was itself a message, and ratified the removal recommendation without modification. Raymond Caldwell was removed from the Superior Court bench on a Thursday morning. He was escorted out of the building by courthouse security, which he had always considered a function that existed to serve his authority. It was a disorienting reversal. He surrendered his bar card 18 months later, when the State Bar's investigation concluded, and offered him a choice between voluntary surrender and a formal disbarment proceeding. He chose the surrender. He spent the following years in a diminished private practice doing document review, living in a smaller house, playing golf on a public course, and being recognized occasionally in restaurants by people who recognized his face from the clip. When that happened, he paid his bill and left. Vivienne Cole sat in her office on the 17th floor on a Thursday evening, 6 months after the hearing. The city spread out below the windows in its gorgeous, sprawling indifference, not caring about any of this, just being Atlanta, loud and hot and relentlessly, presumptuously alive. James knocked and put a new stack of files on the edge of her desk. 3 more for review, he said. One's been pending since 2019. She pulled the top file toward her. How's the caseload looking overall, she asked. Down, James said. Complaint volume is down, which means either we're doing the job or people stopped believing complaining helps. He paused. I think it's the first one. She looked at the file. She thought about what she knew about fear, not the fear she had felt standing at that podium, which had been minimal because she had controlled the entire environment, but the fear she had watched ripple through that gallery on the day of the hearing. The fear of the elderly man in the church suit who had looked at the floor. The fear of the public defender who had stuttered through 11 interruptions. The fear of the Spanish-speaking grandmother whose nephew had been silenced mid-sentence. That fear was the real subject of this work. Not Raymond Caldwell specifically. Caldwell was one man and one man could be removed. The fear was structural, systemic, a condition that accrued in the bones of people who had spent their lives in spaces where they were made to feel that the rules applied to them differently, that justice was calibrated against their presence, that the institutions supposedly built to protect them were actually just additional arenas for the same hierarchies they navigated everywhere else. The work of changing that was longer than one hearing, longer than one removal. It was generational work, incremental work, the kind that didn't have a single clean climactic moment but rather accumulated quietly over years until one day the aggregate of it was visible in the data, in the complaint volume, in the way junior judges who came up after the reckoning conducted themselves in rooms they thought no one important was watching. Every room has someone watching. She opened the file, she picked up her pen, she got back to work. Here is what Raymond Caldwell never understood, and what this story keeps trying to teach anyone who will sit still long enough to hear it. Power that depends on the other person's ignorance of your power is not actually power. It's a performance sustained by a particular arrangement of information. The moment that arrangement changes, the moment the person you're performing dominance at turns out to have a fuller picture of the situation than you do, the performance collapses. It doesn't just pause, it doesn't just stall, it collapses completely, because it was never built on anything structural. It was built on assumption. Caldwell assumed. He assumed because of the blazer, because of the shoes, because of the folder, and the glasses, and the rounded shoulders, and the quiet voice. He assumed because his assumptions had never cost him anything before, and the absence of consequence had calcified those assumptions into certainty. He had stopped being able to imagine a version of events in which the person standing at that plaintiff's podium was more powerful than he was, because his entire model of the world told him that wasn't possible. Not with that blazer, not with those shoes. Vivienne Cole understood something that Caldwell, for all his 19 years on the bench, had never learned, that the most powerful position in any room is frequently the one that looks the most like it has nothing to lose. She walked into that courtroom with everything. She left it with more. He watched her go, chuckled to himself, and went to lunch. He didn't see her again until she was sitting in the chair that controlled his future, reading his worst words back to him in a room from which there was no exit and no appeal that would change the outcome. Patience, precision, and the willingness to be underestimated. That is the full armor, that is the complete kit. Wear it well.